Good morning, Judge Kathree-Setiloane.
Good morning, Chief Justice.
How are you this morning?
Very well, thank you. Very well,
Thank
thank
you.
you.
Thank you once again for making yourself available. I know that at least this is the third time you are making yourself available for appointment to the Constitutional Court. We appreciate the fact that you continue to make yourself available and come to the interviews. I was there when you were interviewed in October, as were many of the commissioners who are here. Other commissioners were there when you were interviewed in April last year as well. We do have before us the transcript of your interview in October, and we have obviously your CV and the questionnaire. So we have all that information. I, for one, will not be asking you many questions because through that interview, I got to know what I wanted to know as much as possible. And it may be that other commissioners will take the same view, but there are commissioners who were not there in October, and they may want to ask you much more than maybe some of us. But obviously, every commissioner who wishes to put questions to you will be allowed to do so. So I'm going to ask you a few questions just to refresh our memory about some of the basic information about you. Mm-hmm. And after that, I will then allow commissioners to put questions to you.
Thank you, Chief Justice.
Yes. In terms of your academic qualifications, you obtained a BA degree from the University of Natal in 1988. Is that correct?
Yes.
Oh, I just realized now that, so you must have been a student at the University of Natal, at least for part of the time when I was a student there.
Yes, probably. We probably were there at the same time.
Yeah.
I may have been doing my undergrad when you were doing your postgraduate.
Yeah, well, I finished my LLB in 1986, but so you must have been doing your first year or second year.
Yes.
Yes. And then you did your LLB in 1991 you got it from that university in 1991.
Yes.
And in 1993, you obtained your LLM from Georgetown University. Is that right?
Yes, that's correct.
And you practiced subsequently as an advocate for, was it about 14 years?
Yes.
Yes. And then you also clerked at the Constitutional Court, is that right?
Yes, at the inception of the Constitutional Court.
Yes. And you have been a judge in the High Court now for how long?
Approximately 12 years, I think.
About?
12 years.
Yeah, about 12 years. And you have acted in the Labor Appeal Court and Labor Court, as well as Competition Appeal Court. Is that right?
Yes, and the Supreme Court of Appeal.
And actually, you have been appointed to the Competition Appeal Court or not?
No. There were not any vacancies at the time, and a vacancy in the Competition Appeal Court came about at the same time that this vacancy was advertised.
Yes.
And the previous vacancies were advertised.
Yes.
So I couldn't apply for both, and I had to choose which to apply for.
But you have acted a number of times, both in the Competition Appeal Court and the Labor Appeal Court?
Yes, I've been acting in the Labor Appeal Court since, I think, 2014, and in the Competition Appeal Court since 2017 or 2018, yes.
And you acted in the Constitutional Court for about, was it 6 months or about a year?
For 6 months in 2017.
Which you enjoyed very much, is that right?
Yes, absolutely. It was really one of the highlights of my career.
Yes.
Acting in that court.
Yes.
It was an honor indeed.
Yes.
And I acted in the Supreme Court of Appeal in 2016.
Yes. Okay. And you have written Well, when you were in practice, you appeared in a number of matters which subsequently produced reported judgments. Is that correct?
Yes, yes.
And you have listed them in your in the questionnaire.
Yes,
And you have also written a number of judgments that have been reported, both when you were sitting in the High Court and when you were sitting in the Labour Appeal Court and the Competition Appeal Court and the Constitutional Court. Is that correct?
yes, yes, Chief Justice.
Yes. Yes, I will now allow commissioners who wish to ask you questions to do so. As they do so, they will be seeking to satisfy themselves how you meet the criteria which this commission uses. And I just mentioned the criteria. There is criteria as stated in the Constitution, and the question there is the particular applicant an appropriately qualified person? 2, is he or she a fit and proper person? And 3, would his or her appointment help to reflect the racial and gender composition of South Africa? And then there are supplementary criteria. Is the proposed appointee a person of integrity? Is the proposed appointee a person with the necessary energy and motivation? Is the proposed appointee a competent person, technically competent? That is A. B, capacity to give expression to the values of the Constitution. 4, is the proposed appointee an experienced person? A, technically. B, experienced in regard to values and needs of the community. 5, does the proposed appointee possess appropriate potential? 6, symbolism, what message would be given to the community at large by the appointment of the particular candidate? So commissioners will ask you questions, but largely they'll be seeking to get information from you that will help them see how your appointment would meet those criteria. Thank you.
Thank you, Chief Justice.
Do you have any questions? Minister?
Thank you, CJ. And good morning, Judge.
Good morning, Minister Lamola.
Thank you. My question relates to the decision you participated in on the Spark Group Limited versus Absa Bank Limited, on the discretion that the bank must use to inform the beneficiaries or the payees on EFT payments. Do you think this is also important in a society like ours, which is also unequal, lots of poverty? Do you think that banks also have a role to play to protect the most vulnerable on their day-to-day execution of their transactions?
Yes, indeed, Justice Lamola. One's belongings and one's savings and one's salary that goes into a bank, particularly those of the disadvantaged groupings in our society, is very important to them, and it's important for their existence and livelihood. And it's important for the bank to safeguard those possessions of vulnerable people. So before a bank takes steps to, that may cause, or to reverse any payments for that matter, there's a legal duty on them to take steps to ensure that they don't cause economic loss. It's particularly important in the case of individuals that depend on the banks to safeguard their possessions and safeguard their interests. Yes.
Thank you, CJ.
Thank you, Minister. Commissioner Nyambi.
Thank you, CJ. Morning, Judge Kathree-Setiloane.
Good morning, Commissioner Nyambe.
It's only one question.
Okay.
As the CJ has indicated, you presented yourself from the same position twice last year. How different are you today from the judge that presented herself previously? Something that you think can stand out that we have to seriously consider?
Yes, I think I'm more tempered. I think I'm a calmer individual. I think it helped me grow in strength. It helped me develop as a judge. It helped to point out what is needed from a judge in terms of one's strength, in terms of one's character, in terms of one's humility, in terms of one's patience as a judge, in terms of one's ability to be fair and objective, and in terms of one's ability to be unbiased. I think this room brings a lot of wisdom to any candidate that appears before it.
Thank you, Judge. Thank you, CJ.
Thank you, Commissioner Lucas.
Thank you very much, Chief Justice. Good morning, Judge Setiloane.
Good morning, Commissioner Lucas.
It's good to see you again.
Lovely to see you too. Thank you.
Yeah, I was saying to the previous candidate that we are feeling like a family already.
Yes.
The way we have been in short time seeing each other. But it's not my issue. I see you've made quite a contribution on issues like gay and lesbian marriages, and also I read your article or part of your article that you have critiqued on CEDAW and so on because of the role that I've been allocated to in Parliament. There is one thing that I don't know whether I've asked it before, maybe I didn't get the chance, but now I'm getting the chance. There is still the issue of Customary Marriage Act and how women are not just, particularly the women that are under customary law, not just getting a just dispensation. What is your view around that? Thank you.
Yes. I think the intention of the Act is good, to regularize customary marriages and to ensure that women married under customary law, because they choose that, it's a choice of law that they choose, and they choose to be married under it, that they're treated equally as individuals that are married under the civil law system. I do think that the Act has good intentions. I think the Act needs to be properly implemented. I know the default position is that the marriage is a common law marriage and not one, is a marriage in community of property and not one out of community of property. I do think that, customary law must also be consistent with the Constitution and the values espoused in the Constitution. So to the extent that customary law is not, it will have to step up and the courts would have to intervene to make it consistent with the Constitution. I know in terms of customary law, particularly women in rural areas are not aware of what their rights are under customary law, and they can often be subject to abuse. So it's important for lots of education to occur around the meaning of the Act, the consequences of the Act, and what the consequences of customary law marriage is. The point is that the Act basically aligns customary law marriages with the values of our Constitution and the Bill of Rights. And I think there needs to be a lot more education around the protections that the Act offer to a woman who chooses to be married under that regime.
Thank you very much, CJ. I never got such a perfect response because it's exactly what the women feel. That
Okay,
is the issue. Thank you. Yeah.
Thank you.
Commissioner Moiman.
Thank you, Chief Justice. Good morning, Judge Setiloane.
Good morning, sir.
Just one question from my side, prompted by what caught my attention on your profile, page 23 of book 1 of book of 2. In paying tribute to the former Deputy Chief Justice, Justice Museneke, you reviewed an article titled "A Warrior for Justice," essays in the honor of the Museneke. I'm interested in what are your key salient features that you are bringing forth to your readers in response to key critical questions around the structural limitation of our economy that were canvassed by the Deputy Chief Justice in his book. Thank you, Chief Justice.
Yeah. Yes, sir. The article basically recounts and celebrates Justice Muneke's unique understanding and vision of the transformative project of the Constitution. It considers his views on the political and economic challenges facing South Africa in achieving economic justice and the role of and the challenges facing the judiciary and the framework of constitutional, transformative constitutionalism. He raises issues of, we have an ideal constitution that basically provides for socio-economic rights, and there's an indivisibility between socio-economic rights and civil and political rights. Your civil and political rights are really meaningless unless you have the means to achieve your social and economic livelihood. And he talks about how it's a joint project between government and civil society. And he touches on issues of corruption and how that has affected the lack of political will, how that has affected the pure economic justice and the enhancement and the entrenchment of, in fact, the realization of socioeconomic rights of ordinary citizens, in particularly the disadvantaged groups. And he says that, he talks about, to the extent that you can't only view this as government's task. He accepts that sometimes the will is not there, sometimes there are issues of corruption and other structural issues that affect economic justice and the achievement of meeting all of these socioeconomic rights. But he also says individuals have basically their own agency, and they as well, working together with government in their private capacities, can help build, the means to attain economic justice. And the article basically recounts, to what extent, we have this wonderful constitution that provides all of these rights and entrenches these rights. And what is the difficulty that is, what are the challenges that are faced? I mean, I do think that it's quite important now. We've been so involved with political cases. The Constitutional Court, the High Courts have, in the recent years, been so involved with political cases that have come to them that there's a need now for NGOs, for communities to basically bring matters to the court that basically will give content to the socio-economic rights in the Constitution. The right to housing, the right to education. We've had cases coming to the court, but in the first, I'd say 10, 15 years, but in the last 10 to 15 years, there's been a decrease in those cases coming to the court. And it's really important given the challenges faced by government in terms of its resources, in achieving fully the socio-economic rights of its citizens, and particularly the vulnerable groupings, I think there's a need for civil society to basically constantly test the Constitution through the courts in relation to the achievement of socio-economic rights.
Thank you, Justice Setiloane. Thank you, Chief Justice.
Thank you very much, Judge President Lekgodi.
Good morning, colleague.
Good morning, Judge Lekgodi.
You and the CJ, you make me feel very bad about my age, because you start talking about the 80s, and I ask myself where I was in the 80s. And I'm start asking myself as to whether I'm not the most senior person in this room. Because I'll be turning 68 this year, and I'm asking myself how young you were at that time. Okay. Two of the criteria, as part of the, I want to ask you questions on two of the criteria mentioned by the CJ. The first one is the candidate having the capacity to give expression to the values of the Constitution? And this is where I am. Are you that kind of a candidate? And if so, do you have one judgment that perhaps if you have to pat yourself back, you will do so? You can mention that.
Yes, I mean, I think
the second criteria that I would want you to respond to as well is, what message would be given to the community at large by the appointment of a particular candidate? And I want you to respond to this question in the context of the current composition of the Constitutional Court judges. You may proceed.
yes. Yes, I think I've dealt with a number of constitutional matters that deal with, various provisions of the Bill of Rights. In the SPA group matter, I developed the common law. In the Residence of Industry House, the application concerned the constitutional validity of Section 13(7) of the South African Police Act, which was a post-constitutional enactment. It gave extended powers and intrusive search and seizure powers to restore public order and ensure the safety of the public in a particular area. And it permitted warrantless searches. And those warrantless searches basically constitute an infringement of the rights of the individuals who were subject to these searches. I mean, they were treated, not only were their privacy rights infringed, but their dignity rights were infringed. In the middle of the night, their homes were raided. The police entered without a warrant. And I mean, these were people that were eking out a living in downtown buildings, the city of Johannesburg. There could have been a different way for the city to basically ensure that there was control in those buildings. But the police, in fact, stepped in to protect the owners of the buildings, and they used these warrantless searches as a means to evict these communities from these buildings. So I think that's an important judgment. It was a full court decision. It dealt, with a frontal challenge to the privacy rights, to the Police Act, which implicated the privacy rights of individuals. And the Constitutional Court then upheld their judgment, and they confirmed the order that was granted in the judgment and the unconstitutionality of the section in the terms in which we had granted the order. So that decision makes me proud. There's the decision of the Contingency Fees Act, you know, in terms of which attorneys were basically taking advantage of RAF litigants because they were entering into common law agreements with RAF litigants, contingency fee agreements, in terms of which they charged, you know, 3 or 4 times what the Act allowed. And I think that's an important matter because we stepped in to put a stop to that practice.
Which judgment is that one?
The Bobroff matter.
Okay.
The Bobroff matter. Yes, Judge Lachori, I'm committed to the transformative project of our Constitution. I'm committed to social justice. You know, the rule of law is an important component of our democracy, and you know, I believe that to a large extent, we need to take a kind of victim-centered approach to the manner in which we protect rights of the vulnerable groups. So, I mean, there are a number of constitutional judgments that have been involved in.
Yeah, I think insofar as the first one, I'm happy
Okay.
with the explanation that we gave.
Yes.
But the second issue is what message would be given to the community at large if you were to be appointed, and take into account the current complement
Yes.
of the Constitutional Court.
Yes. I mean, the Constitution currently comprises of 5 male judges and I think 3 female judges. In the last round of the interviews, the president, and that's entirely his prerogative, appointed 2 male judges to the Constitutional Court, which brought the complement basically to 5 male judges. The Constitution makes it quite clear that the judiciary needs to be transformed. It makes it quite clear that there's a need for the courts to reflect the gender composition and the race composition. And I think I'm a woman judge. I think that's important for the court to be equipped with more women judges. I will, as a woman judge, add to the representativity of that court and the diversity of the court. I think it's very important not to just pay lip service to the issue of gender, but to actually make appointments of strong, competent women. You don't only appoint women because they are women and for the sake of being women, but you appoint women that are competent, that are skilled in a particular area of law, and that are committed to the objectives of the Constitution.
Thank you. Thanks, Chair.
Thank you, JP. At this stage, I would like to go to the commissioners who are attending virtually. Commissioners attending virtually, is there anyone who has a question?
It's Commissioner Malema here. Morning, Judge.
Yes, Commissioner Malema, go ahead.
I'm on virtual, Judge.
Yes, Commissioner Malema is attending virtually, just at one. But go ahead, Commissioner Malema, and ask your question.
No, mine is not a question per se, Judge. It's just to wish you well because we keep on trying. We don't know what's going wrong, but we hope we'll succeed one day.
Thank you. Thank you, Commissioner Malema. It's lovely to have a vote of confidence from you. Thank you very much.
Thank you, Commissioner Malema. Is there any commissioner attending virtually who wants to either put a question or put a wish?
It's Glynis Breitenbach, Chief Justice. I have no questions. Thank you.
Thank you, Commissioner Breitenbach. Commissioner
No question.
No question.
Thank you.
Thank you very much.
No questions, CJ. Just
Thank
to
you.
wish her a good luck.
Thank you very much. You've
Thank you
got
very
another
much.
good luck.
Thank you very much.
Commissioner Singh,
Very briefly, thank you, Chief Justice, and also wish good luck. Good morning, Justice Setiloane.
Good morning, Mr.
Uh,
Singh.
Your response to JP Lakoti, when you mentioned the criteria in the end, I just want to ask you, firstly, do you feel you ticked all the boxes?
Yes, Commissioner, I do believe I've ticked all the boxes.
Thank you. Right. My question then relates to a follow-up on Commissioner Lucas about customary law and customary marriages. I think you're familiar with the Bwania judgment that was taken to the Concourt on live-in partners and their rights in terms of maintenance and inheritance. It's now referred to Parliament, and I think the Minister is dealing with that. We've been given 18 months to deal with the legislation because the Concourt didn't want to interfere in the affairs of Parliament. What do you think about that particular judgment? I know it's law; it's a judgment that's come out of the Concourt, but there were some very strong opposing views within the Concourt bench at that time.
Yes,
So-
Mr. Singh, I'm sorry, I didn't read the judgment, but I'm aware of it. But I didn't get an opportunity to read that judgment, yes. But in terms of the rights of live-in partners, and certainly when a live-in partner is part of a relationship for an extended period, then I think there must be recognition of that extended period that a living partner spent in that relationship. And it should be accorded with the rights that are accorded to persons in civil unions and in marriages, provided they can show that there was this permanent relationship and certain obligations, and there was a community in that partnership.
I'll leave it at that, Chief Justice. Thank you. Thank you.
thank you, Commissioner Singh. Commissioner Mapisa Ngakula.
Thank you very much, and good morning, Judge Setiloane.
Good morning.
I also want to wish you well.
Thank you very much, ma'am.
CJ, I have no question, but I want to comment about two key judgments you have made. No, one. The one is the groundbreaking judgment which you made as far back as 2004-06, when you instructed the executive to allow for same-sex marriages to be recognized, and with the result that we now have a Civil Union Act. I'm the minister who directed to do that, and I can assure you it was one of the most traumatic at the time experiences to have to effect that. Reason being that at the time you took that kind of decision when it was not fashionable for South Africans to even mention or even talk about the LGBTQI community. And I think for that, it's something which South Africans should commend you for. But the other comment I would like to make is, I see that part of your programs have been to place women who are in the bar from poor communities. You've placed them to work in disadvantaged backgrounds with large corporate firms. And I just think that that's a very good program, particularly in the context of South Africa. Now, I would then want to make a plea with you, because we have been discussing, even at the last interviews, one of the things which was pointed out, particularly by advocates, Matole Lepo, is the fact that government and corporate firms, amongst others, do not give work, assign work to young black women. And I see here your focus has been to women from disadvantaged backgrounds, and you've done that by placing them in large firms. And therefore, I would expect that when you go into the Constitutional Court, part of your responsibility still would be to continue to advocate for this amongst your colleagues who are equally judges in the Constitutional Court? Because there are very few of you who are advocating for women, black women in particular, to receive these kinds of assignments so that tomorrow they too are eligible to sit there and be appointed as judges. So thank you very much. I also wish you the best.
Thank you, Commissioner. Thank you very much.
Thank you, Commissioner Mapisa-Ngakula. It does look like, oh, Commissioner Matolo Tlepu.
Thank you, Chief Justice. Good morning, Judge.
Good morning.
I know that I echo the sentiments of Commissioner Mapisa-Ngakula. And one of you, I know that you are very passionate about training women. But now my angle is you are very passionate also on the socio-economic rights to be brought, matters to be brought to the Constitutional Court. One of my concerns is that we tend not to uplift our customary law and make it a South African common law. We tend to be focusing on Roman Dutch law and other. How do you see us uplifting our South African law to be our common law, especially taking into consideration the customary law?
That's very, very important, Commissioner. You know, we know that there are three graces of the law. There's the civil law, there's customary law, and there's the common law. And customary law is always treated as the step sister. So, you know, it's important for the courts to take on the challenge in developing customary law or developing the common law to basically take into account customary law. I mean, customary law stands as an independent, pluralistic choice of law, but it also, given its flexibility, given its the important role it plays in dispute resolution, etc., I believe that it can play an important role in the development of the common law. And I think that's a challenge that the courts need to take up in basically looking at ways of infusing the common law with customary law, rather than, you know, developing the customary law to be consistent within the common law. You need to basically have these two systems infused into each other, and perhaps in that way we will give importance and essence to customary law, and you know, in the hierarchy of the laws in the country. Yeah, so it's very important for courts to take on that challenge. And I know recently in the Bidika judgment dealing with the enforcement of contracts, Justice Saron made it quite clear that Ubuntu plays a major role in determining whether or not a contract, you know, should be rendered unenforceable or not. So I believe there's room for the courts to basically look at customary law and how it can enhance its value in line with the value system of our Constitution. You know, the Constitution makes it quite clear that the common law must be developed in line with the spirit, purport, and objects of the Constitution, and so must customary law. I can't see why these two systems can't be infused into each other, stand side by side with each other, and be given equal prominence in our jurisprudence.
Okay, thank you, Chief Justice.
Thank you, Commissioner. Commissioner Baloyi.
Thank you, CJ. Good morning, Judge.
Good morning, Ms. Baloyi.
In the previous interview, and it's not just you, but other candidates as well, the issue of the delays in the delivery of judgments by the Constitutional Court has become a recurring theme. And answers differ, and I see when what Mr. Madonsela put to you was issues about the length of the judgments, perhaps they could be kept simpler, and you agreed that might be one of the ways to, you know, to avoid the long delays. But I wonder if that is the only way to look at it, or in fact a fair way to look at it. And I want to put this proposition to you, that when when the first court, constitutional court, if I may call it that, was conceived, and the provisions in the constitution, there's a prescription of sitting, at least 8 judges must sit. That is a completely different environment altogether. It didn't contemplate your 17th Amendment, for example, which expands the jurisdiction of that court, and therefore the load of work that comes to that court, that was not contemplated at the time. And it isn't perhaps the conversation that we should be having that is that provision, that requirement that at least 8 must sit, still relevant to the environment in which that court is operating today? Should we not be looking, I mean, you've got the SCA, which is not, doesn't sit 8 people because, you know, there's no such prescript, and maybe there isn't enough judges to do that. Is the rationale still sound? We have now an established jurisprudence, constitutional jurisprudence. We're completely different landscape when you look at our jurisprudence from what it was at the time that that provision was conceived. And isn't that where we should be addressing the problem about the delays in delivery of judgments, 1, and then 2, shouldn't the Constitutional Court itself, of course through the right office of the Chief Justice, be agitating, because you have the lived experience in that court, be agitating for changes?
Yes. Yes, I agree with you, Commissioner. I don't, you know, the workload has increased, I don't know, 5-fold from the early days of the Constitutional Court. And you're quite right. The foundations of the jurisprudence are there. And it's an application now of those, the foundations that were basically put in place in the first, I'd say, 10 years of that court. You know, most of the rights content has been given to it. You know, it may be helpful that you know, given this increased jurisdiction of the court, because all matters are now infused with constitutional law. You know, so every matter that goes there, there's the contention that this is a constitutional matter. If it's not a constitutional matter, it's a matter of you know, that has an arguable point of law, that is of sufficient public importance, and it needs to be dealt with. Everybody, all litigants are taking their matters from the Supreme Court of Appeal, from the High Courts, even where the Supreme Court of Appeal has refused leave to appeal. It still goes to the Constitutional Court for another bite at the cherry. And the numbers have just increased. And it's very difficult for the judges to manage that. I've been told by some of the judges in that court, they've now put in a different system to deal with the application for leave to appeal, where in the past you had 2 judges on duty every week. Now you have 1 judge on duty, and the judge is allocated a set number of cases. You know, in the past, the practice was you could get 30 cases in 1 week, and the next group of judges sitting in the second week would get no cases. So there was this disproportionate load in some judges, and that impacts on the judgment writing of the court. But perhaps the court, and the court needs to basically look at making representations, you know, in relation to how it sits. Perhaps they can sit, they don't have to sit on bunk all the time, you know, with having a minimum of 8 judges, or 11 judges. They could sit in benches of 4. I mean, I think Judge Zondo may have been involved with that in past years, where it was envisaged that, you know, in labor matters, you'd have kind of labor specialists within the Constitutional Court dealing with that. And you don't have to have all 11 judges, for instance, sitting there, all 8 judges. You could have a smaller group of judges. So all depending on, you know, and also some of the application for leave to appeals, they take very, very long to finalize those applications, because you've got to go through 11 judges. You know, every single decision that is made, every single recommendation that you make, you have to make it to all 11 judges and all 8 judges that are involved in the matter. Or, you know, and it kind of lengthens the period of finalization of anything. So perhaps, you know, the court needs to make representation on how it can streamline the work and how it can change the manner in which it sits, but still deal effectively with matters. But it would obviously need a legislative amendment. But certainly you can look at ways of bridging this difficulty that the court is experiencing, because it's incredibly difficult. You're dealing with judgments in current matters. You're dealing with judgments in past matters. You have judges presenting judgments. You go to two or three drafts at their judgment. You decide at some point in the process that you wish to dissent. Sometimes that's 3 or 4 months after the original, the scribe presents its judgment. That delays the judgment for a further 5 or 6 months before it can be handed down. There's the whole editorial process which the clerks are concerned with. It's an important part of judgment writing that the judgments are properly edited, that the judgment is checked for consistency with previous judgments, that the judgment is checked, the citations are checked. So it's an incredibly long process. I mean, I understand how as a single judge, that process takes so long for a single judge. But when you sit with 8 judges or 11 judges, that just increases and prolongs, the finalization and the delivery of the judgment. So I do think the point you make is valid. Perhaps the court needs to look at ways and how it can bridge these difficulties by making these representations to Parliament.
Thank you. Thank you, CJ.
Thank you, Commissioner. Commissioner Pillay.
Thank you, Chief Justice. Good morning, Judge Kathree-Setiloane.
Good morning, Ms. Pillay.
Perhaps I should begin with a declaration that I was your pupil many years ago when I first joined the bar.
Yes.
Judge Setiloane, just tagging on to a question raised by Judge President Lekhodi earlier about giving expression to the values in the Constitution. Now, you're known not only for being an ardent champion of women's rights, but you're known for your commitment to the enforcement of the rights of the LGBTQI plus community. Yet one of the issues not yet specifically dealt with by the Constitutional Court is the rights of trans and non-binary or gender-neutral persons. And my question really in relation to this is twofold. Firstly, whether you consider that the current constitutional and legislative framework is sufficient to protect the rights of trans, non-binary persons. And secondly, and just drilling down to court process and the experiences of both litigants and witnesses as they appear in courts, how it is that we ensure that judges adequately recognize and respect the rights of people to their chosen gender.
Yes, I think it's important. I think the court, I think the Parliament has put in protections for this community of people. They, however, face violence at the hands of heterosexual people, essentially, in the townships. They can't, it's difficult for them to exist in certain communities. And that goes to the broader question of violence, gender-based violence, because they become victims of gender-based violence. I think that, yes, the courts are going to be dealing with these issues more and more. You have transgender people appearing in courts as witnesses. I think we need to be, particularly in assault cases, in other gender-based violence cases, and one needs to be sensitive in the same way that you are sensitive to the needs of women who are victims of abuse. In the same way you are sensitive to gay and lesbian people, in particular women, who are subject to abuse and violence in their communities. I think the courts have to be sensitive. I think it's important also at the level of reporting these cases to the police, for the police to be sensitized on how to approach and how to deal with cases of a person who chooses, chooses a particular identity over what their birthed identity would be. And I mean, there are now amendments to the Domestic Violence Act in terms of the different groups that are protected under this regime. And vulnerable groupings are now, people from vulnerable groupings are now given protection under the Domestic Violence Act. And I think, well, obviously, transgender people will fall, you know, within the vulnerable groups. They've experienced terrible violence in their communities at the hands of heterosexual people, in particular heterosexual men. And the police need to make a concerted effort. I think Parliament has now put in these protections. Also how, you know, the evidence can be taken and the sensitivity in which the courts need to deal with the evidence that they give in court, and to treat them like they would treat any other individual, any other litigant that is a witness in their courts, I suppose.
And just sorry, Judge Kathree-Setiloane, just to follow up on the second part of the question, and that's really around practitioners and litigants who appear in court and who choose a non-binary identity. How it is that you can get judges now to begin to firstly understand and respect that choice.
Yeah, I mean, I think to the extent that litigant or counsel chooses to take on a particular identity that is non-binary, that needs to be made clear to the court. Unless it's made clear to the court, you are not going to know. And if you wish not to be referred to as a he or a she, then that must also be made clear to the court. And perhaps that could be done in chambers before hearing by counsel or an attorney who wishes to be addressed in a particular way. And to the extent that the litigant itself chooses to take on a particular identity, but non-binary identity, then that must also be addressed with the judge, and the judge must be sensitized to this. So in open court, the judge doesn't make an error, and that could be embarrassing, and it could be offensive to the individual concerned, I think.
Thank you, Judge. Thank you, Judge, Chief Justice.
Thank you. I only have two names, and those would be the last ones unless something else happens. Commissioner Jesse.
Thank you, Chief Justice. Judge, just one question. You acted in the Constitutional Court. Now, assuming a judge who act in the SCA, receive an application, therefore leave to appeal, dismiss it, and is appointed to act in the Constitutional Court, that matter can appear before that judge. What are his obligations? Is he allowed to sit, decide also on the very same matter that he has decided in the court accord?
Yeah, I think you would ask to be recused if a matter comes, leave was granted, a leave was not granted at the Supreme Court and the judge was involved there. I think there's an obligation on that judge to bring it to attention of the other judges that he or she was involved in the decision not to grant leave. And that particular judge can be excused from the panel. You don't have to have all 8 judges, a minimum of 8 judges in leave to appeals. You could, do that number, as long as I think there are 5 judges that can decide the issue, then that would be appropriate.
Thank you very much, Judge.
Thank you. Commissioner Tsepe.
Thank you, Chief Justice. Good morning, Justice Kathree-Setiloane. Justice Setiloane, Kathree-Setiloane, in your response to the question raised by Commissioner Baloyi, you were looking at various mechanisms on how some of the delays in the Constitutional Court could be dealt with. And a thought just came to mind, and I wanted to find out what your view is, because I think this is one of the mechanisms the Constitutional Court may be trying to deal with in order to have matters expeditiously dealt with. There has been a number of cases where the Constitutional Court is making decisions on some matters which are not leave to appeal without hearing parties. And I wanted to find out from you whether you think that is a good practice, and what kind of cases other than leave to appeal cases do you think that practice, what kind of cases would be best suited for that kind of a practice? And if we were to hear it in respect of all matters, what could be implications? I'm thinking on amici who may want to appear in those matters. I just wanted to hear your thoughts on that. Thank you.
Yes, I mean, I think, Commissioner Sepe, you get the matters that are kind of full-blown constitutional matters that are dealing with important aspects of the law that concern, the larger public interest, that will have a larger impact. I mean, I think all of those cases, the court is very clear that those sorts of cases need to be dealt with. These very high-profile cases that deal with the issues of separation of powers, that deal with the powers and functions of organs of state, that deal with the violation of fundamental rights in areas of the law where the court hasn't made decisions as yet. Those sorts of matters the court deals with in open court hearings. And there are matters where there may be a violation of constitutional right, but the court has already developed the law in that respect, and some of those cases then get discussed in chambers, and judges allocated that particular judgment to right. It may be an issue of costs in the labor court regime, and what the constitutional obligation is in relation to cost in that court. That's something that could also be dealt with by an individual judge, with just having a chamber discussion with a conference discussion with judges, and you don't need. So there are lots of matters that actually get dealt with on that basis, where, and that helps as well, because you don't have to, there doesn't have to be a thesis on the law. You're not developing the law. You're not making new law. You're really applying principles that the court has already developed. And the court is doing that to a large extent. And yes, so that helps also to kind of bridge the difficulty and the challenge that the court experiences. Yes.
Justice, thank you.
Thank you, Commissioner. We have come to the end of this interview, but are there 3 or so points that you wish to emphasize to the commissioners that they must take into account in considering your candidature, or are you satisfied that you have mentioned either in writing or in your answers all the important points?
I think I've covered all the important points in my application.
Yes.
I think it's important to take into account that it's important to increase the capacity and to increase the composition of women judges on the court. So that's something that needs to be taken into account. I think you have 2 strong women judges that are appearing before this panel today, and that appeared before this panel in the past. And I think you need to look at our skills. You need to look at our judicial philosophy. You need to look at our contribution to the law. You have to look at what our contribution can be, should we be in the Constitutional Court. I think as a women judge, I have, in the 12 years, proved myself as a judge. I have shown my commitment to the transformation of the judiciary. I've shown my commitment to the transformation project of the Constitution, to the value system of the Constitution. I have ample experience. I'm an all-round judge. I went from being a public interest human rights lawyer to doing constitutional law, to doing competition law, to doing commercial law, to dealing with cases in labor, to dealing with broadcasting, complex telecommunication cases.
Thank you. You are now excused. Thank you very much for making yourself available.
Thank you very much, Chief Justice, and thank you very much to all the commissioners.